I wrote back in March about the oral arguments in the case Espinoza versus Montana Department of Revenue. The court has released its opinion, so I thought that was worth a review. Now, once again, it is not so much the outcome of the case, but the opinions that are of real interest to the constitutionally minded Americans. So let's take a look at this opinion next on the Constitution Study.
There's one thing you have to know wherever you make your stand. Came from a long through line of everyday Americans.
Hello there, everyday Americans. Paul Engel here once again with the Constitution Study, where we read and study the Constitution, where we teach the rising generation to be free. And I am so glad you could join me. Please head over to that website, constitutionstudy.com. Let me know what you're thinking. Ask a question, write a comment, sign up for the newsletter, sign up for some of the programs, buy a book, whatever you can to engage. You know, the last few months have been very difficult from a constitutional and right standpoint, and it's really up to us to make sure we are educating ourselves and educating our children, because I'm pretty sure that the government isn't. You can also sign up for the Scholar program, find out more about that up on the website. But let's get in and talk about this case, Espinoza versus Montana Department of Revenue. From the opinion, held. The application of the no-aid provision discriminated against religious schools and the families whose children attend or hope to attend them in violation of the Free Exercise Clause of the federal Constitution. The opinion of the court was not really a surprise. As I wrote back in March, it was quite obvious that the argument that the no-aid provision, what's called Rule 1, could not violate the First Amendment to the Constitution of the United States since it was not based on a law from Congress. Quote, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. However, since the language in the Montana Constitution mirrors the First Amendment, having its own establishment and free exercise clauses, the arguments in this case could just as easily been made based on the Montana Constitution. However, since the Supreme Court of Montana had already set aside the entire tax credit law, what were the plaintiffs to do? So as I said in March, a case could be made that the state's Blaine Amendment, prohibiting state funds from supporting religious activities or organizations either directly or indirectly, was a violation of the 14th Amendment's Privileges and Immunities Clause. What I did find interesting in the opinion, though, was the concurrence of Justice Thomas. The court correctly concludes that Montana's no-aid provision expressly discriminates against religion in violation of the Free Exercise Clause, and it properly provides relief to Montana religious schools and the petitioners who wish to use Montana's scholarship program to send their children to such schools. I write separately to explain how this court's interpretation of the Establishment Clause continues to hamper free exercise rights. Until we correct the course on this interpretation, individuals will continue to face needless obstacles in their attempts to vindicate their religious freedom. Again, this law cannot violate the First Amendment to the U.S. Constitution since Congress did not make a law. But no one is perfect, not even Justice Thomas. And since the Montana Constitution has the same language except restricting the state rather than Congress, Justice Thomas's arguments, well, they work pretty well when we apply to the Montana's religious freedom clauses. Quote, this case involves the Free Exercise Clause, not the Establishment Clause. But as in all cases involving a state actor, the modern understanding of the Establishment Clause is a brooding omnipresence, ever ready to be used to justify the government's infringement on religious freedom. Under the modern but erroneous view of the Establishment Clause, the government must treat all religions equally and treat religion equal to non-religion. See, Justice Thomas states that while the case was brought based on the Free Exercise Clause, the real problem is with how the court has treated the Establishment Clause. He goes on to explain. As this court stated, in the first case applying the Establishment Clause of the states, the government cannot, quote, pass laws which aid one religion, aid all religions, or prefer one religion over another, close quote, from Everson versus Board of Education. This equality principle, the theory goes, prohibits the government from expressing any preference for religion or even permitting any sign of religion in the government realm. Thus, when a plaintiff brings a free exercise claim, the government may defend its laws, as Montana did here, on the grounds that the law's restrictions are required to prevent it from establishing religion. Notice something important here. The court did not apply the First Amendment to the states until Everson versus Board of Education case in 1947. This is when the court suddenly decided that not only was Congress prohibited from establishing religion, but that no government is allowed to permit any sign of religion. This grossly errant interpretation has been used ever since to quash any exercise of religion on public land or in a public building, to prevent even the appearance of the establishment of a religion. In effect, this is the government establishing secularism, the belief that only this world matters, as the only religion defined as any system of faith and worship, the only religion acceptable in public places. Continuing from Thomas's concurrence, this understanding of the Establishment Clause is unmoored from the original meaning of the First Amendment. As I have explained in previous cases, at the founding, the clause served only to protect states and by extension their citizens from the imposition of an established religion by the federal government. This is what happens when the courts elevate their own opinion above the actual language of the law. They invent novel interpretations to meet their agenda. They twist the plain intent of the Constitution, then use these opinions to push their agenda forward. Even worse, by elevating their opinions above the law, courts have routinely used them to infringe on the rights of others, as Thomas noted. Quote, the court has also repeatedly stated that a government has a compelling interest in avoiding an Establishment Clause violation altogether, which may justify abridging other First Amendment freedoms. That's right. We've seen plenty of cases where governments have used the court's opinion about the Establishment Clause to abridge the rights of citizens. What a mockery, to use the First Amendment to infringe on the rights that are supposed to be protected by it. Quote, the concern with avoiding endorsement has nevertheless been used to prohibit voluntary practices that potentially implicate free exercise rights, with courts and governments going so far as to make the remarkable suggestion that even while off duty, a teacher or coach cannot engage in an outward manifestation of religious faith. See, one of the cases Justice Thomas is referring to is Santa Fe Independent School District versus Doe, where the court opined that a teacher's voluntary decision to begin football games with a prayer violated the Establishment Clause. See, in an effort to protect people's freedom of religion, the court infringed on a person's freedom of religion. Ultimately, this decision brings justice to the families who brought suit. However, the court's dependence on stare decisis leads even those who support the opinion to do so in a twisted manner. This has become so ingrained that even when Justice Thomas points out that it was not the original intent of the First Amendment to be applied to the states, he does just that in his concurrence. Now, I did not spend time on the Alito concurrence or Justices Ginsburg, Breyer, and Sotomayor's dissents, as they fell pretty much along the lines I covered in the article on the oral arguments. But I close with what I hope you will see is why I spend so much time on details and definitions, why I think it is dangerous to get to the correct conclusion using the wrong method. Quoting from Thomas's concurrence, the court's current understanding of the Establishment Clause actually thwarts rather than promotes equal treatment of religion. Under a proper understanding of the Establishment Clause, robust and lively debate about the role of religion in government is permitted, even encouraged, at the state and local level. The court's distorted view of the Establishment Clause, however, removes the entire subject of religion from the realm of permissible government activity, instead mandating strict separation. As Justice Thomas said, the court's understanding of the Establishment Clause thwarts its primary purpose. Rather than allowing religion to be freely exercised and allowing the states to determine the role of religion in public lives for themselves, the courts have placed the public discussion of religion off limits, except where they have made exceptions. So while I cheer for the Espinoza and other families in the suit, I fear for the future of our country, as it is still led by people more interested in preserving their own opinions than supporting the Constitution that they swore or affirmed to do when they took office. So for those of you who've been following this case, I hope this is an interesting follow-up. I tried not to retread what I'd covered with the oral arguments, but I thought Thomas's concurrence was rather interesting in that it really went into this idea of the courts are getting it wrong. They're getting to the right conclusion, but the fact they're doing it the wrong way, using the wrong standards, means that a lot of people are having their rights trampled upon. This is why it is so important that our elected officials exercise their authority to make sure the judges maintain their office only during good behavior. When judges put their opinion above the law, that is bad behavior, and according to Article 3, they're supposed to stop serving. I'm not talking about getting impeached for a simple opinion. We can all disagree about a lot of things. But Justice Thomas makes a very important point. The court has a tradition now of infringing on people's rights, on violating their oath of office, because a court in 1947 made a bad decision. And because of that bad decision, they have decided to elevate that above the actual law they swore to support. Well, our elected representatives, especially those in the House of Representatives, also swore an oath to support the Constitution. That includes a clause that says federal judges only serve during good behavior. So as much as I complain about the courts, I'm really more interested in the House of Representatives. The fact that they seem unwilling to hold the court in check, to make sure it behaves properly, that it behaves good, that they've abdicated their responsibility to hold the court accountable, to make sure that those who hold that office do so only during good behavior. So while, again, I'm very happy for the Espinoza and other families, I'm still sad that we still live in a country ruled by oligarchs who don't bother paying attention to the law. They're much more interested in upholding their previous opinions. So I hope that made you think. I hope that was a good follow-up. And for those of you who also joined me in supporting the Espinoza and other families, I hope we'll also recognize the dangers of what was done here. And I hope that you'll come back and I'll see you the next time on the Constitution Study.
There's one thing you have to know wherever you make your stand. Came from a long